Someone has died and you want to commence a probate estate in the state of Michigan, and you want to do it by an application for informal probate. Hi, I'm Darren Findling from the Probate Pro, and we're going to talk about probate administration in Michigan with the use of an application for informal probate. We're speaking specifically of the area in this particular timeline that's highlighted with the circle, which is the beginning of the probate administration process when somebody has died. There are a variety of ways to open an estate. One is by an informal process and an application for informal probate, and the other is with a petition for probate, which is a formal process in which you typically appear in front of a judge to commence the probate administration, admit the will, and so on. The informal process is used usually when everyone is getting along, when you don't expect there to be any difficulties or any concerns relating to the admission of a will. So be careful about which process you choose at the onset, because when you pick that process, whether it's by application for informal probate or by a petition for probate, it sets the course for the remainder of the probate administration, including restrictions that may be placed on your letters of authority, so that you as personal representative may have different powers depending on whether you commence it by application or commence it by petition. Let's walk through the document. Highlighted is the title of the document, which is an application for informal probate and or appointment of personal representative for testate or intestate. Testate meaning with a will, intestate without a will. This can be done with a will or without a will. And in the bottom left corner, I've identified the form PC 558, which is a SCAO form, a pre-approved form through the state of Michigan. The next is that you're going to identify the county. And the county that you're going to file this is either going to be in the county in which the decedent was domiciled, or if they were domiciled outside of the state of Michigan, the county upon which the property is located. So for example, if the person was domiciled in Oakland County, you'd file this in Oakland County. But if they lived in Missouri and had no probate administration in Missouri, but owned a piece of real estate in Oakland County, you'd also use Oakland County. The next section is quite simple. Identify the name of the person who died. And we typically want to identify their name as reflected on the death certificate, and maybe any also known as or alias names, so that if you have to use the letters of authority at various banking institutions that may have used different or less formal names, you can do so. The next is the individual who is filing the application. And there are rules about who has the right to commence an informal probate, and you really have to understand the statutes to understand who has the right and authority to make an application for informal probate. Not anyone in the family could do so. The next area relates to basic information: date of birth, time of death, date of death, last 4 digits of the social security number, and the domicile identification of where they were living. And that's a statement so that the county can identify whether you're in the right location. The next area identifies whether there's a death certificate or whether you're using any other form of proof of death, and then any of the interested parties. And this is a critical piece here. You have to identify all the interested parties of the estate that are affected by this, and these are dictated by a court rule and the statute. So you really have to identify them correctly, because your failure to do so subjects you to the penalties of perjury, because that form is signed under the penalties of perjury that you're identifying the correct people. Failing to identify the correct people can really subject you to some pretty significant penalties, as well as removal as the representative. The bottom area we already spoke of. It's an identification of why venue is correct and whether jurisdictionally you have the right to file this in the state of Michigan. The back side of the form identifies the information regarding whether it's testate with a will or intestate without a will. And those various sections of subsection 6 identify whether you are providing the court the will or or it's already in the court's possession. Now, critically important is that with an application for informal probate, you are not adjudicating the admission of the will. It doesn't occur in this process because you're not in front of a judge. So it's very important that if you're unsure about whether that will is going to be formally probated or you need it formally probated, you do not use this process. And again, this process should really only be used in certain circumstances. The next area, again, is to identify if there were any other validly executed wills, as well as whether there have ever been appointments done in any other jurisdiction. The next area identifies who you are nominated to be as personal representative and any person that has a higher ranking of priority under the statute. Again, very critical that you understand the relevant provisions of the statute to understand whether you have the highest order of priority and what other people have the right to priority above. The next area identifies really what you're requesting the court to do. If you're asking the court to informally probate the will, you're asking the court to informally appoint a personal representative with or without a surety bond. These are the areas there. And then at the bottom of the form, again, you are declaring under the penalties of perjury that you've examined the document and that you are indicating that the contents are true to the best of your information, knowledge, and belief. If there's a lawyer, the signature will go there and the applicant's signature will go there. Now, this is not the only document that you bring down to the court when you're ready to file this. It includes a copy of the death certificate, of course, the will, and a testimony of interested parties. And we'll give further explanation about how that process works. Most importantly, this process is just not simple to do. So if you're struggling with this and you can afford having a lawyer assist you and guide you through the process, I strongly, strongly, strongly encourage you to do so. You can reach out to us for questions, 877-YOUR-FIRM, or visit us at theprobatepro.com.